Hello, Hussein.
Hello, just confirming everyone can hear me.
Yes, I can hear you.
Great, thank you.
So Wesley, can you hear me?
Yes, I can hear you.
Okay, you can start now.
Okay. All right. I think it's exactly 4:30 by my time now. Okay, please, I want to confirm if everyone can hear me.
I can hear you.
Yes, we can hear you.
Okay, thank you so much. So hello, everyone. It's my pleasure to have you join us for week 7 of the Gypsy Mentorship Program for the 3rd quarter of 2022. And on behalf of Mrs. Juliana Imam, the convener of this program, I would like to welcome and recognize the presence of our distinguished mentors present, and of course, our outstanding and ever committed mentees. So my name is Sewese Yaji Aondo. I'm a lawyer and ADR practitioner and the founding partner of Prime SPG Legal Consult and Advisory, and I reside in Abuja. So I'll be your anchor for the program today. Okay, so to formally begin the program, I would like to give a brief introduction of what the Gypsy Mentorship Program is all about. So the Gypsy Mentorship and Internship Program is a quarterly program for students and young professionals across Africa. In this combined mentorship session, we have mentees from the Intellectual Property Mentorship and Internship Program, the Artificial Intelligence and Technology Mentorship and Internship Program, and finally, the Fintech Mentorship and Internship Program. So we seek to allow mentees the opportunity to access valuable advice, training, network, mentorship, internship, and access to discussion forums, industry updates, and resource materials from experienced mentors. So this program also seeks to encourage continuous training, development, and evolution in Africa and around the world. So you can watch our videos by searching Gypsy, hashtag Gypsy MIP, that's hashtag JIIPCC MIP on all our social media platforms, including YouTube and Facebook. So the objectives of the Gypsy Mentorship Program are to provide easy access to quality professional guidance, training, and resource materials for students and young professionals in Africa, and to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders. Okay, so to further proceed with the program, I also like to make some few announcements. So the registration for the 4th quarter of the Gypsy Mentorship Program for 2022 is ongoing. So we have the link displayed on the screen. You can reach out to interested persons, colleagues, friends, anyone interested in furthering a career or knowing more about intellectual property, fintech, artificial intelligence, health tech, and law, patent drafting, and of course, the energy industry can apply. And okay, we also have ongoing registration for the end of year party as well. Is going to be on the 10th of December. The get together is going to be on the 10th of December 2022. And we're looking forward to that, getting to meet our mentees and our mentors physically. So we encourage everyone to register and plan towards the event. And then we also, apart from the general mentorship program, there's also provision for private mentorship, 30 minutes private one-on-one mentorship. Is paid, of course, it's not free. So interested persons are advised to also reach out to us and then apply as well. So to further continue with the program, all mentees are advised to turn on their videos and then edit the Zoom section, the name section on their Zoom accounts to reflect their full names for attendance purposes. And please be informed that this program is streamed live and is also recorded. All right, so thank you. We'll proceed now with reading out the mentors profile, the profile of our mentors. So on the program today, we have 4 mentors. So we'll go ahead and read their profiles in no particular order. So I'll begin with the profile of Emmanuel Ewere. I don't know if I got that right, but I'm hoping that I pronounced it correctly. So the topic is technology, data protection, and intellectual property. That's the topic we're considering for today, for week 7 of the program. And I'll go ahead to read the profile of Mr. Emmanuel Ewere. Mr. Emmanuel Ewere is well versed in the digital realm due to his work as a technology lawyer. He works in the United Arab Emirates and Europe and provides services like software, license agreements, hosting agreements, and telecom contracts, as well as data protection and intellectual property rights services to IT companies. He's constantly learning about modern technology and the risks that come with implementing these new technologies. He was awarded a master's degree in information technology law from the University of Tartu in Estonia. So that's all for Mr. Emmanuel Ewere. We welcome you, sir, to the program today. We're glad to have you. So I'll go on to read the profile of the second mentor that we have today. Okay, so the second mentor we have today is Mr. Mim Owundiwe. I don't know if I got that right as well, but pardon me if I didn't. Okay, so Mr. Mim Owundiwe is a, sorry. Okay, thank you. Okay, Mr. Mim Owundiwe is fascinated by legal issues around AI, space technologies, and innovations on the African continent. Owundiwe helped to build Evisort, an AI company from the Harvard Innovation Lab while in law school, and currently serves as Executive Vice President of Legal and Business Intelligence. He also founded and chaired Harvard's Legal Technologies Symposium and is on the advisory board of Innovation Law Club Africa. His article, Africa and the Artemis Accords, a review of space regulations and strategy for African capacity building in the new space economy, was published in a peer-reviewed journal on space entrepreneurship and innovation, attached in a featured section. Owundiwe spoke on a high-level panel at the 2021 National Space Society's International Space Development Conference and was a speaker for the summer workshop on teaching space. in brackets SWOT, a program developed by faculty at the Air Command and Staff College to train graduate students interested in space pedagogy. I hope I pronounced that right. So as a student at Harvard Law, Onwidire served as president of the Harvard African Law Association and co-editor-in-chief of Harvard Kennedy School's Africa Policy Journal, where he was fortunate enough to meet and interview leaders from across the continent, including H.E. Nana Akufo-Addo of Ghana and His Excellency Olusegun Obasanjo of Nigeria. Okay, so Mr. Mem Owundiwe, we're glad to have you on the program today. I will look forward to hearing from you as well. So the next profile I'm going to read out is that of our third mentor, that is Senator Ihenyen. Okay, so I'll proceed. Senator Ihenyen is the lead partner at Infusion Lawyers, where he leads the intellectual property and technology practice of the virtual law firm. He advises both local and global companies in various areas of law, including copyright, industrial design, patent, and trademark. A blockchain law expert, Senator has also advised on protection and monetization of non-fungible tokens, that's NFTs. Senator was a guest speaker at the World Intellectual Property Day in 2018, organized by Friends of the Creators Artistic Foundation, Delta State, Nigeria. In 2020, he served as a judge in the WIPO National Intellectual Property Essay Competition in Nigeria 2020. Senator is a faculty member on intellectual property at the ESQ Practical Lawyers Academy, an intellectual property and information technology law mentor at Legal Mentorship Program, LEMP, and mentor at the Juliana Imam Intellectual Property and Creative Consults Mentorship Program, that's Gypsy. Senator is currently the first vice chairman, Intellectual Property Committee of the Nigerian Bar Association, and a member of the Information Technology Committee of the NBA section on business law. Senator is the current president of Stakeholders in Blockchain Technology Association of Nigeria, CBAN, a self-regulatory body in Nigeria's emerging blockchain industry. He doubles as the General Secretary of Blockchain Industry Coordinating Committee of Nigeria and Fintech Alliance Coordinating Team. So, Senator Sir, you are welcome to the program. I also look forward to learning from you as well. So I'll go on to read the profile of the fourth mentor, Mr. Gabriel Udo. Gabriel Udo is a research fellow and doctoral candidate at the Faculty of Law, Europa Universitat Viadrina, Frankfurt in Germany, and recently won the Dutch Academische Ooststaatsdienst funded position under the VIP Fellowship Program for the research project, Intelligent Weaponry, Laws and Ethics. His research specialties are centered mostly on artificial intelligence and law weapons technology, smart city technologies, and international humanitarian law, robotics, autonomous currently. Currently, Gabriel is a Beyond Fellow in the Ethics Group of the Observation International AI Future Lab on Artificial Intelligence for Earth Technique Universitat Munich. He holds a master's degree in international law, several machine learning, Python certifications in artificial intelligence programming for data analysis, UAV and small robotics. He has several publications in both local and international journals. Gabriel, having presented papers in India, Sweden, Austria, and others in these research areas. At leisure, Gabriel plays the piano, chess, develops programs with Python, and listens to music. So we're glad to have you, Mr. Gabriel, on the program today, and we look forward to learning from you. So to proceed with the program today, and the reason why we're here today is to also give room for our mentees to learn and also avail us the opportunity to learn from them as well. So I'll go on to the PowerPoint presentation by our mentees. And we have 4 groups for presentation today. The presentation is from the IP mentorship group, and we have 4 groups represented today. And I'd like to invite the group representatives of the various groups to get ready. We'll start with group 1, if group 1 is ready. Okay, so if group 1 is ready, please unmute.
Yeah,
so
I'm ready.
Okay, thank you so much, Uzowa. I don't know if I got that right.
Yes,
okay,
Uzowa.
So yes, thank you. You have 8 minutes for your presentation, and would want to adhere strictly to this timing. So please structure your presentation in such a way that it can accommodate the time allotted. Thank you so much. I'll also be interrupting from time to time to give you information on how much time you have left. Thank you. So you may please proceed.
Okay. Can everyone see my screen?
Yes, we can.
Okay, please, I'm coming.
Okay, that has gone off, I think.
Okay, yeah. Okay, so good evening, everyone. My name is Ibuchin Uzowa. I'm the presenter for Group 1, and we're giving the topic Introduction to Blockchain, NFTs, and Smart Contracts. Okay, so intellectual property creations, especially digital works, are usually subject to replication due to the fact that there's a lot of high increase in technological advancements, but non-fungible tokens can be seen as a solution against this replication due to the fact that they cannot be easily replicated, they cannot be easily reproduced. NFTs are seen as digital tokens that usually represent the encrypted version of word items or objects. Minting and sales of NFT covers or affects the copyrights, affects trademarks, affects designs, and affects patents. So blockchain and IP rights. Blockchain is one of the frontier technology that affects businesses and industries nowadays. It is famous. It is a famous technology behind cryptocurrencies that we hear of nowadays, and it is a method of storing digital data records in a decentralized way. It is also an open ledger information that help in keeping track of transaction and records. Okay, moving on, we'll be talking about determination of creatorship and unregistered IP rights in blockchain. We all know that it's very hard for one to prove ownership of a particular intellectual property work that has not been registered, and it is also very hard for an owner to gain protection when he or she has not registered his work. But blockchain comes in as a solution or as a protection for these works that are not registered, due to the fact that it enables a permanent recording of transaction. That is, there's an evidence of transaction. For example, I am a designer. I put my work up on the blockchain technology. There's usually a cryptography identity, like an identification card, that is linked to that work, that links that work to me in years to come. You can know that, okay, this design it actually belongs to Gucci, it actually belongs to her, that kind of thing. That's what blockchain helps. It gives creative works a cryptography identity. So we'll be talking about blockchain and trade secrets. Trade secret is one of the widely recognized uses of blockchain technology due to the fact that it protects data due to its encryption. Most people don't really understand what a data is when it's encrypted. They can't really understand what it means. So trademark registration, if blockchain is embraced or is is if blockchain technology is embracing IP, it will help to simplify trademark registration. It will help to ease the burden of evidence for you to prove, okay, who is the owner of this particular work, who has this, who has that. It helps to simplify maintenance. It also helps to simplify the process of application. So we're talking about NFTs now, NFTs and IP rights. Non-fungible tokens are seen as digital tokens that are stored on the blockchain. Like I said, they represent real-world items. They cannot be destroyed, they cannot be replicated, but they can be bound. When they attempt bond, this simply means that they cannot be transferred. Yes, but
Can we all hear her? I can't hear her.
No, I think we've lost her.
So who is the backup presenter? Please, you can continue from where she stopped. Backup presenter for group 1, please.
Okay, anyone from group 1? Group 1, please. Anyone to back up? Okay, so if there's no backup presenter, I think we'll just move to group 2 while they try to reconnect. So group 2, please. The representative for group 2, could you please unmute?
Yes, I am here.
Okay.
Can everyone hear me?
Yes, we can hear you.
Thank you. Hi, everyone. My name is Mr Emmanuel, and I'll be presenting on behalf of Group 2. Let me just share my screen quickly.
All right, you have 8 minutes, Nyembe. Please try and structure your presentation within that time.
Sure. Can everyone see my screen?
Yes, we can.
Yes, we can see your screen.
Thank you. Cool. So the topic of today's presentation, which is artificial intelligence and virtual reality, introduces the 4th industrial revolution, also known as Web 3.0. It's about the ability for users to explore the application of innovation and automation and to fundamentally change the way people work and experience day-to-day life. Artificial intelligence and the existence of virtual reality is the peak of today's technological age. Though they are both still at their stage of theoretical discussion, these technological developments require careful consideration for both businesses and individuals in order to take advantage of the opportunities they present and to understand the potential pitfalls that they also present. As a way of putting into perspective the progression of these technological developments, let's briefly look at how we got to the age of 3.0. Now, so 1.0, Web 1.0 was the age of static web pages retrieved from servers, where internet users at the time were delighted by the novelty of emails and real-time news. Over the past 15 to 20 years, the web pages of Web 1.0 have been completely replaced by Web 2.0's interactivity, social connectivity, and user-generated content. Web 3.0 will be a new version of the internet and enables users to own and control the assets and content they create, also referred to as a decentralized internet, meaning that the underlying technologies are not centralized on servers owned by individuals or organizations. In other words, no permission is needed for a central authority to post anything on the web. This implies freedom from any indiscriminate censorship and encouraging maximum participation and experimentation. So let's get into our first topic, AI. There is no uniform definition of AI, but at its core, it is a science of teaching computers how to learn, reason, communicate, and make decisions like human beings. AI has existed in some form or another for decades. Its scope and application has expanded in recent years. For example, in 1995, it was an amazing development when people could use predictive texting on their phones. The technology gave texters the ability to press just a single key for each letter, which unlocked a whole level of typing speed and transformed how people would use their phones. Now, due to the increased computing power, improved algorithms, and the accessibility to large volumes of data, we have an AI virtual rapper. They call him robot rapper by the name of FN Meka. I would encourage everyone to look into this character. He is a good example of what's amazing and not so amazing about AI algorithms. The increase in popularity of AI technology also brings with it significant legal and regulatory risks. I will briefly highlight a few issues that are currently being discussed in the AI community. So first, commercial transactions and negotiation points. Organizations who use AI in their operations, products, or services can either develop AI capabilities themselves or license AI systems from a third party. Accessing an AI system from a third party would typically require a software license, and a key component of licensing transactions may raise unique negotiation issues surrounding warranties and indemnification liabilities. Parties would need to consider warranties surrounding an AI system's performance and output capabilities, and would need to adequately address the potential business impact of an AI system failure, including warranties covering injuries and other damages caused by AI-enabled machines and devices. Most of us have read headline stories coming from the US about fatal road crashes from Tesla's autopilot EVs. When consumers or businesses purchase or license similar technology, they must make sure to consider the technological safety risks and who bears liability when an AI technology fails. The next we're going to look at is data ownership and data protection. Now, AI systems rely on large quantities of data. AI-based service agreements should therefore include provisions to allow a vendor to accumulate and aggregate consumer data. Vendors and service providers should be prepared to negotiate data ownership and use terms. Further, if the data in question includes consumer personal data like healthcare-related data, then parties need to include additional protections and restrictions to comply with privacy laws and regulations. Group 4 will educate us further on this topic, so I'm going to quickly move on. Next, we look at IP ownership in AI products. Now, in the traditional IP context, ownerships of a patent originally vests with the inventor, a copyright automatically vests with the author, and a trade secret belongs to the entity taking the necessary steps to protect it. By default, ownership of AI-related IP, such as patented AI system, copyright source code, or a trade secret dataset follows these rules. However, issues may arise regarding ownership of inventions and software or other valuable data created by AI itself, where the AI develops an improved apparatus, generates valuable datasets, or self-generates a computer code. Let's briefly look at the case of Tenant Technology Beijing, where the company developed an algorithm-based intellectual writing assistant system called DreamWriter, with a focus on personalized context and business for businesses. Tencent Technology licensed the computer software to the plaintiff, Shenzhen Tencent, who published a financial reporting article on the Tencent's security website and noted that this article was automatically written by Tencent robot DreamWriter. On this basis, the defendant, Shanghai Yongshun, without Tencent's permission, reprinted the article on their website. Shenzhen Tencent sued Shanghai Yongshun on the grounds of copyright infringement and unfair competition. The court raised two questions here. First, whether an AI-generated work can become a work protected by copyright law, and second, the status of ownership of copyright in AI-generated works. The court found that the content generated by DreamWriter software constituted a written work. The court did not break away from the general legal rule that works must be the result of an author's intellectual creation. In order to argue that the AI-generated object constituted a work, the court especially emphasized that the article in question was generated by the creative team of Shenzhen Tencent using the DreamWriter software. Some courts have emphasized in the judgment that the creation of a natural person would still be a necessary condition for a work to be copyrighted under copyright law. But it remains to be seen whether an auto-generated product of AI can be a work protected by the copyright law.
Okay. Nyembe, you have 2 minutes left for your presentation.
Sure, thank you.
Thank you.
Lastly, we can briefly look at employers who also need to consider implications of AI in the workplace, such as introducing AI-powered intelligent robots, such as drones, automated floor cleaning robots, and industrial auto carts that work alongside employees. Employers would need to consider how to deal with workplace safety and accident investigations, third-party recovery for workplace injuries, and termination and layoffs of displaced workers. Next on the conversation is virtual reality. In its current form, virtual reality in its current form, though still developing, is considered a simulated three-dimensional digital environment or platform, which mixes the real world with the virtual world and allows a real-time virtual experience. The metaverse is an example of a VR platform or virtual shared space that intends to provide humans with the virtual experience. Let's have a look quickly at key important terms surrounding virtual reality and the metaverse. First is your avatars, which are your on-screen representations of the user, and which becomes the user's virtual presence in the metaverse. A user can move his or her avatar in the metaverse using technologies such as full body sensor recognition to conduct activities such as walking and jumping. Next is NFTs, non-fungible tokens. NFTs and smart contracts are essential for the metaverse. World to function optimally. I was going to leave this conversation to group 1 to continue, which I hope they'll still be able to talk us through. So one of the few things that we need to look into legal implications of VR is, again, data protection. The definition of personal information in most data protection laws includes identifiers such as a person's name, signature, identity number, etc. And personal information in the metaverse may become more complex should it include personal identifiers like facial expressions, eye movements, and even avatar movements such as a hand gesture or a pose, which may be construed as personal information if they identify a person. The metaverse poses interesting questions about what constitutes personal information, and I hope that our mentors today can help us answer the question whether an avatar could be considered a legal person. Next is cybersecurity. Cyberbullying, sexual harassment, and any other types of cyber crimes are present on online platforms and are currently very difficult to police. There are endless opportunities for cyber criminals to operate in the metaverse, more especially because of the nature of NFTs, which would allow cyber criminals to operate anonymously and unregulated due to blockchain technology. Oh, apologies for that.
Okay, I think you should be rounding up.
Yes, next I'll look at personality rights. We can use an example of Alfonso Roberto, known as Carlton on Fresh Prince of Bel-Air, who sued the makers of the video game Fortnite for copyright infringement after he claimed that the game used the Carlton dance without permission. Although Alfonso has now dropped the suit, users should be careful not to infringe personality rights of famous persons, as these are already recognized terms, recognized laws rather in various jurisdictions. I think I'll just head off to my conclusion. I'll just leave the trademark conversation to maybe group 1, and then it is clear that advances in AI and virtual technology, advances in AI and virtual reality platforms such as the metaverse hold the potential to fundamentally reshape the way we live. It is also true that the transformative nature of AI technology and virtual reality platforms will impact how we apply certain laws and policies. Like any human or system, AI is not accurate. For this reason, its deficiency might result in detrimental consequences in our society where important decisions are delegated or to imperfect systems. Further, the nature and classifications of NFTs, smart contracts, and the metaverse are still in their infancy in many jurisdictions. Businesses that need to expand into the metaverse will need to be mindful of numerous legal issues in the race to capitalize on the opportunities in the metaverse. Thank you for the time, everyone.
Okay, thank you, Nyembe. the representative of Group 2 for the presentation. And so we'll return back to the presentation for Group 1. If Uzowa is ready, you can continue with the presentation.
Yes,
Group 1,
I'm ready.
please.
I'm ready.
Okay.
Sorry.
Okay, please turn on your video. So you had about 5 minutes left when you were disconnected. So please try and work with that.
Okay. Okay, please, can we all see my screen?
Yes, we can.
Okay, so I was talking about NFTs and IP rights, and I was explaining to us that NFTs cannot be replicated and they cannot be destroyed, but they can be termed non-transferable. So NFTs and IP rights, I'll be talking about trademark. We all know what trademark is. Trademark is like logos. They include logos, names, and the rest. It's just mainly for you to know a particular source, for you to trace a particular goods to a person. It enables brand exclusivity. Take for example, like Chanel, Nike, Adidas, and the rest. We actually link it to a particular person. So trademark registration provides the brand exclusivity, and it also eases ownership development, and as well providing collaboration opportunities and licensing. Okay, so moving on, we'll be talking about a case study. That's Nike Incorporated versus StockX LLC. So I'll just be summarizing what happened in this case. In this case, as I said before, NFTs can be used. They represent a particular item or product. So in this case, Nike trademark had an NFT, and StockX was trying to make use of that particular NFT that represented their trademark. And Nike came in to say that, okay, take it down. This NFT is actually representing my trademark. And then StockX came up saying that NFT do not represent physical products and the rest. Although the motion is still pending in court, because Nike was able to show evidence that they were actually selling counterfeit products and the rest. And then StockX could not actually say anything as regarding such claim against them. So this case goes to show that you can actually bring up a claim concerning your NFT that is being infringed on, or that is being that someone is trying to violate or make use of without your permission. So we'll be talking about NFTs and copyrights. We all know what copyrights are. Copyrights include visual work, literary work, artistic works, and so on, provided it is original and it is fixed in a tangible form of expression. So many NFTs qualify for this as they are original and have a large degree of creativity. Going further, we're talking about NFTs and design. Like I said before, NFTs they are not actually the product or assets in themselves, but they are representing a particular product, they are representing a particular asset. So design protection is on the product or the asset that the NFT is representing, provided that it meets up with the criteria for protecting of designs. And the design must be ornamental, meaning that it has to be visual. You cannot say, okay, my NFT is a sound and it's a design. You can't really register on that design. Yes, provided it can be visible on a computer screen, then design protection is possible. So going further, we're talking about smart contracts and IP rights. We all know what contract is, where I promise to do something for you, you promise to do something for me. There's consideration, there's offer, there's acceptance, and the rest. Nick Zizabo in 1990s defined smart contracts as a set of promises specified in digital form, including protocols, which the parties perform on those promises. That's the same thing with smart contract is almost the same thing with the natural language contracts, just that there are a little bit of difference. Like the natural language contracts, it affords it enables the courts to interfere or interpret and give judgment in relating to such contracts, unlike the smart contract, which is usually in the form of a computer program or in the form of software and the like, just that there are little features from the natural language contract, they are embedded in the smart contract. So my group posed a question, and the question is, can smart contracts replace natural language contracts presently? And we said no, not presently. Okay. If we look at my slide, we'll see the stages of development of smart contracts, and we are currently in stage 2 of the development. Stage 2 is where we already know the rules, and then we only apply those rules to complex cases. We don't really apply it generally to all cases, just only some specific and complex cases that we apply them to. And smart contract has not been able to replace natural language contract due to the fact that there are still some limitations, and then there are still some contrast in lifestyle. Okay, so case study of smart contract. We see a couple who translated their prenuptial agreement into an executed smart contract. We see of a game known as an online game known as CryptoKitties, which is played through the implementation of the smart contract. And famous example is IBM Trust Food, which have gotten recognition and has had several advantages over their competitors like Nestle, Dove Food, Kroger, and the rest. This is the fact that they have a digital record book of transaction and interactions from the making of their food products, packaging it, and the rest. It's mostly done through smart contracts. Okay, so in conclusion, NFTs are easy way for artists to get their revenue and to get recognition. So IP ensures that for creators to get this through NFTs, they don't get ripped off in the NFT marketplaces. That is, IP ensures that their products which is being represented through NFT are being protected, and then they have knowledge concerning this, and then they are not taken advantage of in the NFT marketplaces. And then my group also recommends that sellers and minters of NFTs should actually seek the consent of the owners of these NFTs before they go about minting them or before they go about selling them. Then secondly, like Ms. Amosa Shukurat would say, you are the police of your invention. Authors and creators need to be aware, like they need to be vigilant to know when their IP work, which has an NFT they need to be vigilant to know when their NFT, which represent their IP work, is being used without their consent, and then they need to speak up about it. Then lastly, our recommendation is that the NFT marketplaces should guide against infringement. It should be a stronghold against such infringement, like the case study that we gave, Nike Incorporated versus StockX, where they were able to speak up concerning an infringement of their NFT that represented their trademark. They were able to speak up against such use. So we are saying that NFT marketplaces should be able to pull down such infringement. They should have a strong stand against infringement or violation of intellectual property rights in NFTs. Thank you very much. That's all for Group 1.
Okay, thank you, Uzoa, for that presentation on behalf of Group 2. It was detailed and really insightful. Thank you. We'll move on to Group 3 now. Is a representative of Group 3 ready?
Yes, ma'am. Good evening, ma'am.
Good evening, Oluwatofarati. Okay, so please proceed with your presentation. You have 8 minutes. Please structure your presentation within the allotted time. Thank you.
Okay, good evening. Can we all hear me?
Yes, we can hear you.
Yeah, I'm going to be sharing my screen now. Okay, can we see my screen?
Yes, we can.
Okay, so my name is Oluwatofarati Azan. I'll be presenting on behalf of Group 3, and our topic focuses on the intellectual property, legal and commercial development in the data protection and privacy sector. So I'm going to be defining the meaning of data protection. Data protection is a process of safeguarding sensitive information against loss, tampering, and corruption. And data basically means facts or information that one can make reference to later in the future. So data is created and stored at previously unheard rates, and significance of data protection grows. Additionally, there is limited tolerance for downtime Downtime means the period at which a computer is not active. That is the inactive period in which a computer is, so that can prevent access to crucial information. So as a result, a key component of data protection plan is making sure that data can be swiftly restored after any loss or damage. So other crucial aspects of data protection include guaranteeing data privacy and safeguarding data against compromise. So I'm going to be discussing the principles of data protection. To protect and make data accessible in all situations is one of the fundamental principles of data protection. So data backups performed operationally and business continuity or disaster recovery are both covered by the term data protection. The acronym is BCDR. Data management and availability are two areas where data protection are evolving. So definition of data availability means basically to ensure users will always have access to the data they need, to conduct their business, even if it's destroyed or damaged later on. And then the two main areas of data management are utilizing data protection is the information lifecycle management and the data lifecycle management. So data lifecycle management involves basically automating the transfer of vital data to online and offline storage. So information cycle management is a complete approach for categorizing and safeguarding information assets from application and user errors, malware, and virus attacks. So data management has recently evolved to include the discovery of methods to extract business value from otherwise dormant copies of data for reporting, for test or developer enablement, analytics, and other purposes. So moving on, I'm going to be discussing the differences between data protection and data privacy. So data protection in its own way is just means using backup and recovery to protect information against loss. While controlling access to data is referred to as data privacy. So data privacy basically means when the access to a particular data is being, data privacy basically means the controlling of access to any data online. So who has access to data must be determined by the organization. So this is what data privacy entails. So it makes sense that a privacy breach could cause problem with data security. So moving on, I'll be talking about data protection and privacy laws. So data protection and privacy laws and regulations differ from country to country, because the one that operates here in Nigeria will be different from the one that operates in the United States, and also different from the one that operates in the United Kingdom. So, and even from state to state. And the new ones are constantly being enacted. So China's data privacy law became effective June 1, 2017. So the European Union's General Data Protection Regulation went into effect 2018. Meanwhile, in the United States, the California Consumer Privacy Act supports the rights of individuals to control their own personally identifiable information. So experts recommend that a global organization that has a data protection policy that complies with the most stringent set of rules the business faces, while also using security and compliance framework that covers broad set of requirements. So I'll be outlining various data protection and privacy guidelines that applies to all organizations. Number one is safeguarding of data. That is one of the guidelines. And number two is getting consent from the person whose data is being collected. Number three is to identify the regulations that apply to the organization and the data it collects. So I'll be talking about the data protection law in Nigeria. So in Nigeria,
Oluwa, you have 2 minutes left. please.
Okay, so I'll be quick. Thank you. So Section 37 of the Constitution deals with data protection law in Nigeria, and also we have the Nigerian Data Protection Regulation of 2019, and this regulation of 2019 makes provision for the rights of data subjects and obligations of data controllers and data processors. So the rules and regulations contained in this NDPR are the following rules are okay. The rules and the laws that contain provisions of data protection. Number one, we have the Constitution, we have the Cyber Crimes Prohibition Act of 2015, and then I'll be moving on to case laws on data protection. We have two, which are 2022 cases. So the first is Incorporated Trustees of Law versus Zoom Video Communications. This suit was issued in 2020, whereby the Incorporated Trustees sued the Zoom video communication for the non-compliance of Zoom's privacy policy with the NDPR. The suit is currently in court, however. Then number two, we have the Digital Rights Lawyers Initiative versus National Youth Corps. So I'll be moving on to Data Protection Regulatory Authority in Nigeria. So in Nigeria, there's currently no data protection regulator in Nigeria. So as a result, each sector has been in charge of data protection. For example, the body in charge of financial data security is the CBN, while the Nigerian Communications Commission is in charge of regulating the data collected and processed by internet services providers, telecommunications companies. Then I'm moving on to the power, duty, and responsibility of the commission, which the bill seeks to establish. Then Section 9 of the bill provides for various functions of the commission. So I'll be moving on to definition of data privacy. Data privacy also refers to information privacy and is an area of data protection that concerns the proper handling of sensitive data, including personal data, but not other confidential data. So in some parts of the world, privacy has frequently been viewed as a component of liberty, the right to be free from state intrusions. So I'll be talking about the importance of data privacy. Number one is business asset management. We live in a data economy where companies find enormous value in collecting, sharing, and using data about customers, especially from social media. So transparency is how business requests consent to keep personal data. So number two is regulatory compliance, which is managing data to ensure regulatory compliance is arguably even more important. So the legal definition of data privacy, we'll be talking, okay, so none of those prevalent regulations define precisely what is meant by data privacy, and it's left to business to determine what they consider the best. I think I'll be moving to the conclusion. So ensuring
your time is up, so try and conclude. Thank you.
Okay, so in conclusion, so ensuring the privacy of sensitive and personal data can be considered an outcome of best practice in data protection and security, with the overall goal of achieving continual availability and immutability of critical business. So the NDPR should ensure, this is a suggestion by my group, that the NDPR should ensure that the protection of personal data in Nigeria is in consonance with developing global best practices and fills the gap in the regulation, privacy rights, and data protection in Nigeria. Thank you.
Thank you so much, Olua, for that insightful presentation. We'll move on to group 4 now. Is a representative of group 4 ready? Good evening, Oluyinka.
So I'll present it for presentation. Yes, I want to share my screen.
All right.
Come in. Okay. Okay, can everyone see my screen?
Yes, we can.
All right. Okay, so my name is Zoeni Oluyinka, and I'm presenting for Group 4. We'll be presenting Introduction to E-commerce and Fintech. And I will start from what is e-commerce. Okay, so e-commerce is just like a business transaction, a trading online that involves transfer of information through the internet by definition covers a variety of business activities which can be done on the internet. We've seen so many businesses, many online shoppings that we have now. We have the likes of Jumia, we have the likes of AliExpress, Amazon, and we know the services they render and what we get from them. All this kind of online business, kind of trading is what we know as e-commerce. E-commerce also means electronic commerce. And this is like the main importance, the main definition of e-commerce. And okay, like I've said earlier, we have the examples have been listed there. I'll just move ahead so as not to waste our time. Sorry. Okay, so I'll just move ahead to the features of e-commerce. Features of e-commerce has wider range of audience. With the internet at the backbone of e-commerce, business transaction can take place across national boundaries in a more convenient and cost-effective form. Number two, it has universal standard. Internet technology has a universal standard. It's not different. It's the same thing. This way you can get something outside the country, same thing you can get it in the country. And it also give you the ease of interaction. You get to interact with your client, you get to understand what you want to buy, you get to ask questions, and you will be okay. So then personalization or customization, and there's also business digitalization, then automation of business process to increase delivery speed. We have seen so many times where we do our online shopping and we get to order things online. Instead of us having to go pick it up ourselves, it is being delivered to us at our doorstep. That is one of the features of e-commerce. That's what we enjoy in e-commerce. So not to waste our time, I'll just move to fintech. I'll just briefly explain what fintech is all about. I know we are all familiar with what fintech is all about now. Fintech, financial technology. This has to do with taking our financial life and aspects to the technology world. Instead of having to go to bank to make transfer, instead of having to queue to make so many things, it has been made easy for us. We can easily pay with our cards. We can easily pay online. We have so many apps that has been made efficient for us through the use of financial technology. And okay, also, all right, so I'll just move to the intellectual property rights in e-commerce and fintech. As we all know, we know the intellectual property right that we have. That's one of the things we've been taught ever since we started this class. And I'll be starting with copyright. So copyright automatically extends for fintech. Copyright automatically extends to the computer code, visual interface, features, audio, video guides, application program interface, instruction, and other works. Computer code may cover particulars such as source code, studio code, machine code, and purpose-built hardware or firmware. Copyright is an important intellectual property asset for a fintech company, particularly if the program design provides computation and usability efficiency. I will just move to trademark/brand. Brand may include a word, logo, or icon protected as registered or unregistered trademarks, the latter which can prevent competitors from unlawfully passing over or diluting the goodwill of a brand. So for a fintech company develop their brand with quality customer service and trust to establish goodwill in their brand with customers and the general public. So a strong brand, a strong trademark help a fintech company to stand different from their competitors. It gives them the advantage over their competitors. And then I'll move to trade secret. We are all familiar with what trade secret is all about. It's just a way to protect your business information, just a way to protect materials, confidential backup, code, and everything that has to do with your business, everything that gives you an edge over your competitors. And you know that for trade secrets, most time it is included in probably in your agreement with your employees, so that they know that they can't go out there, they can't release the information, they can't do anything about it. So that is why for a fintech company, trade secret is also an important feature, it's an important right you can have. And also another right.
You have 2 minutes. So,
all right, thank you. Another right is industrial design. Industrial design can also be used to protect and also we have trademarks and we have patents, and I think we all know, I don't want to go into much details anymore. And okay, sorry, let me just, okay, for patent provide a mechanism to exclude others from making use or selling the patent technology, which may help companies obtain or maintain market shares and protect research, development, investment. Patent can provide a competitive advantage that may also be used defensively as a negotiation tool. For an example, an organization may protect core innovation in response to assertion to patent by third parties by cross licensing with another organization. Patent publication can also be cited against, and application can be filed and can be granted. Thank you very much. That will be the presentation for Group 4.
Okay, thank you so much, Oloyinka, on behalf of Group 4 for that detailed presentation. So we'll move on now to contributions from our mentors present. I think we'll have all our mentors present, I believe. So we'll give room for our mentors to comment on the presentations from the groups. So we'll start with Mr. Emmanuel Iweri. So you have the floor. I don't know if Mr. Emmanuel is. Okay, if Mr. Emmanuel is not available at the moment, we'll move on to the Mem Owundiwe.
Hi, great. So yeah, I'm happy to comment on on those incredible presentations. I think they're all, very, very, good and strong presentations, and I think the topics that we're talking about are at the edge, right? At the kind of where technology is, so it can be hard to talk about some of these things because of that. But I think that despite the confusion and the lack of clarity on some of these issues, your teams were really able to kind of give solid presentations. So I'll kind of go one by one. I know the Group 1 was, I know really focused from a kind of from the perspective of kind of blockchain, NFTs, and smart contracts. I would say I completely agree with them on kind of the idea that, smart contracts are not yet ready to kind of fully, fully kind of take over what happens. And I think it makes sense when you think about a lot of contracts that happen. You can't automatically, confirm that things have been completed, because those things being completed are things that happen in the real world, right? If I'm a business, it's like, did the food get there, right? Have people been showing up to work? Did we finish constructing this building, And so there's likely going to be an element where you need kind of, humans in the middle there. And I think also from an IP and kind of blockchain NFT perspective, it is, and I think you guys know, I'm also, a co-owner of the African Museum of the Metaverse, right? Which has, NFTs and locations across different metaverses. And, you're right that NFTs help with IP from the perspective of, when you click it, you'll be able to know exactly who created it. But that doesn't mean that there's still going to be that aspect of folks who are out there who might just change one pixel and then try to trick you into thinking it's something, right? And so there is still, and so that idea of, whether or not these different kind of, whether or not these different exchanges like OpenSea, how hard and deeply they go to actually, enforce some of this and take collections down, is a real, kind of a question that's out there. And I'd say for Group 2, I know there's a deeper focus on AI. I'm, work in AI, and so this is probably one that I am able to kind of speak to, the most thoroughly. There's definitely, as you said, kind of concerns. I think a recent case, I think it only happened a couple of weeks ago. I think it's August 5th. There's a case in the United States about whether or not, in the appeals court, about whether or not artificial intelligence can own its own patent. And like the case in China you brought up, the US court said that an inventor must be a natural person. And so that's a recent case of this side, but I do think it's worth an appeal. And I do think ultimately, things will get there. I think a place, if you guys know Dolly, which is a system that does automated art, and automated you can type in things that creates art. Right now, that's changing a lot. As someone who's with the African Museum of the Metaverse sees a lot of NFT artists, a lot of them are adopting that technology. But then the question is, if you're using AI to build your art, does it get some of the proceeds, right? And so a lot of these kind of AI tools, are going to open up questions to, is it the human doing it, or is it the AI doing it? And the law currently is continuing to say that humans are doing it. But I think we all see the writing on the wall that at a certain point, AI it seems to be getting to a point where it's going to be able to kind of do things, on its own. And then for group 3, from a data kind of privacy perspective, I do think there's a lot there too, kind of a big web of things. I think for companies, that we work with, because I work with an AI company that does AI analysis for contracts for different companies. Something that they're always looking at, to your point, is if we're operating in all these jurisdictions, how do we make sure that we're staying in, compliance with all these jurisdictions, especially when they are changing all the time. And I think that, that question of a global one, it would be good. But as someone in the United States, we're having a hard time just having our country come together on one, as different states are doing one. So I think we're far off from a global one. And it's just going to require companies, have more visibility into their contracts, so that when rules and regulations change, folks will be able to adapt. And then lastly, group 4, once again, another great conversation. I'd say from a e-commerce, fintech perspective, one, I think a use of AI that hasn't been brought up, I think dovetails well here, is that, as I said before, NFTs do fix the issues of counterfeit, largely because you can see exactly the asset I purchased, who created it, but it doesn't stop people from making a million things that look exactly like the thing you created to confuse people, right? But the way that people solve that today is many times using AI, and the AI is able to look over different SKUs and identify things that are so close that could be a copyright infringement. And so I think as we move on to NFTs and things like that, those technologies, will persist and remain important. And I guess the last thing there is from a trade secret perspective, as someone also who works at an AI company, I'd say that another piece that's important to think about is trade secrets are important to tech companies that use AI, because when you file a patent, you have to kind of at least write down and tell somebody, and kind of at a certain point make public the underlying algorithms that are there, right? And just like in the same way that Coca-Cola doesn't actually patent its secret formula, it keeps as a trade secret because that's the only way it actually stays a secret, right? And so I think trade secrets are important for companies that use AI, because a lot of times they don't want to publish that. So that's just some of the feedback, but really excellent and well thought out sessions.
Thank you so much, Mr. Mem Owendiwe, for those insights. And so we'll move on to the other mentors present. Senator Ihanye, you can see he's online. Gabriel, Odo, and Emmanuel, any of the mentors who are ready to give input. Okay, thank you, sir. Over to you, sir.
All right, I agree absolutely, right, with Mr. Owendiwe that this has been a very fine presentation from the 4 groups we've had here. I wouldn't want to repeat what he already highlighted. I would just like to point out that I also took notice of Ibuchim Uzowa's presentation, which really emphasized on blockchain, NFTs, and intellectual property. And it's really it's quite vital to understand that as far as blockchain is concerned, like you said, it's really all about encryption and protection, trying to protect data using this new technology. But again, it's not going to be 100% answer to the issues that we have in terms of IP infringements. Of course, we understand that the internet, as we know it, Internet 2.0, as we know it today, has actually become a hotbed for copyright infringements because of the ability it gives people to be able to duplicate anything that gets on the internet, whether artistic works, musical works, copyright, other copyright works as well. But blockchain changes all that by ensuring that for the first time in the history of man, we have a way of also not just communicating over the internet, but also exchanging a thing of value over the internet in a way that is encrypted. And of course, that encrypted thing could be IP actually. So nice one there. I think that I agree with you that blockchain can help to improve IP management. You know, if you look at what WIPO and the others are doing, if they can integrate blockchain in terms of ensuring that IP databases are properly managed, I think it will help a lot. It won't mean, for instance, when you apply blockchain in the NFT space, for instance, that it will be the answer to all of the problems there. As a matter of fact, as we speak today, we already have a lot of copyright infringements in the NFT space, and it's been a lot of it's near disaster because a lot of works, you know, have been taken off from the real world, as he put it, and then brought onto the NFT platforms or marketplaces like OpenSea and the rest of them. And you really can say that because it is NFT, it has protected the user or the owner of the work, not at all. Which brings me to the point I would like to make, that we need to understand that bringing a work into the NFT space does not automatically grant you IP protection. You know, those frameworks or traditional frameworks or legal frameworks we know about copyright protection, about trademark protection, about patent protection, all of that still applies. So never jump from making a work straight onto NFT platforms and expect that that is automatic protection. You're wrong. You need to ensure that you still exploit or use all those traditional avenues available for protection before you jump into the NFT space. Otherwise, you're going to get your fingers burnt, right? You said something about smart contracts, and it's not going to be replacing natural language anytime soon. Yes, I agree with that. What I just wanted to point out, just for the purpose of distinction, is to know that smart contracts is a very broad term. It's pretty broad. And when we talk about smart contracts, it's really more about the computer language or the programmed instruction, pre-programmed actually instructions, right? About transactions happening between A and B, B and C, and all of that. Smart contracts does not really mean what you might be referring to in terms of a contract between two people, like a legal document or agreement, right? If you're looking at legal relationships or agreements, what you mean to say is smart legal contracts, right? So when it comes to smart legal contracts, it takes it away from just this broad term of smart contracts and looks at contracts written for the purpose of replacing the need for those traditional contracts we know that lawyers draft for their clients, right? So I just thought that I should make that distinction. Yeah, that's that. Then I think that for group 2 on artificial intelligence and virtual reality, Yes, with all the buzzwords these days flying out there, we find innovations we've been building, trying to create a lot of innovations. We've heard a lot about Metaverse, this year like never before. And I agree with you that there will still be infringements happening on those platforms. And it was good you were able to identify, I mean, Bosisiwe and Yembe now, you were able to identify some of the risk. And then also you looked at the impact this could have in terms of injuries and all of that. That is a concern. And I think that's why we talk about ethics, ethics a lot in the artificial intelligence space, because if innovators do not, comply with certain ethical standards, we gonna be having a lot of problems in our hands. We already have a lot of problems with human beings. Imagine now that robots gets to, make that even worse. So I agree with you. We have to watch out for those. Your dream writer case that you referred to, it pretty much illustrates how that plays. However, of an innovation-driven person I am, I've always been a bit skeptical about giving robots or AI that recognition that human beings have today. Most of the cases you will find around this would always try to distinguish between the robots, right? In this case, Dream Writer, for instance, and the creators of Dream Writers, which is like the developers or programmers or companies behind it. And I think that this principle is going to stay with us for a long time. Because if you just imagine this, if we were to give the robots Dream Writer all that copyright that we also confer to human beings such as you and myself, when Dream Writer's rights is violated, who goes to court? Who goes to court? Does Dream Writer then go to court and get a client? No. I think that the person who goes to court would be the developer of Dream Writer, right, to protect the rights, conferred on the creator. So I think for a long time, we will see that happening. It will always the law will always try to trace back who developed this. And this is interesting. I find this whole thing interesting because even in the blockchain space, we talk about decentralization. And today, decentralized apps, what we call dApps, are causing problems here and there, right? And the law enforcement agencies and the states, they want to pick up someone who is liable for this. And then when you ask the question, who is liable, the defense is always that no one is liable. It's smart contracts. It's a decentralized community. There's no person and no company. Guess what the Financial Action Task Force, FATF, the global body that is responsible for tracking money laundering and all of that in the financial services space. Guess what they said? They said, okay, henceforth, we will trace back the developers of the program. It's something innovators don't like, but I think for now, that's the best the states can come up with. But it is still evolving. Like Mr. Onwodiwe has said, it's still very evolving. We're still at the edge. A lot of things will still develop with time. And I'm sure that with guys like you making fine presentations like this, we should be able to find our way out. Quickly, data protection by Oluwatofarati Hassan.
Sorry to interrupt, sir. You have about 3 minutes.
Okay, quickly.
This. Thank you.
All right. So Hassan, fine stuff you've done there. The only thing I would like to point out is that bear in mind that although Nigeria does not have a single data protection authority at this time, there are organizations or bodies that are specifically recognized as the data protection in their own various industries. So for instance, the Central Bank of Nigeria will always tell you that they have their own data protection regulation for those in the banking and financial industry. And so they are the authority in that area. If you go to the telecom sector, you'll find the Nigerian Communications Commission as well, playing the data protection authority in that space. And interestingly, the NDPR, which you refer to, specifically also acknowledged this by saying that NIDA is not the data protection authority for Nigeria, but that there are various data protection authorities NIDA is going to be working with. I thought I should point that out. And the distinction you try to make between data protection and data privacy, I think the best way to look at it again is look at data protection from a data security angle, and then look at data privacy from a personal rights, when it comes to violation of personal rights. I think that would be a clearer distinction. Lastly, e-commerce, fantastic one, Oyeni Oluyinka. Although you're a bit quite broad, you didn't have a lot of time to be a bit specific, but good work. You were able to identify all of the key features when it comes to e-commerce. And then you helped to look at how copyright, trademark, trade secrets, patents, and all that play in that area. Hopefully when innovators out there get to see your presentation, they'll be able to sit up a bit when it comes to leveraging all of these things, including IP, to grow and expand their markets. Thank you very much.
Thank you, Senator Nkeyen. It's always a pleasure listening to you, sir. Thank you so much. So we'll go ahead to call on the other two mentors, either of them available. We have Emmanuel Ewere and Gabriel Udo.
Okay.
For want of time, we're constrained to restrict you to 7 minutes for your inputs.
Okay.
Thank you.
Thank you very much, Juliana, for inviting me here again. It's always very exciting to be here. And like I've always said, when I come here, most times I come to learn lots of things. Today I've learned a lot from, it's good to finally meet Senator. And I've read a lot of things, read his story blogs and meme also. It's nice to get to see a face behind the meme. So first I'll quickly say that most of what I would have said, though my research areas is strictly on artificial intelligence, and I try to stick around those corners so I don't make mistakes. Anything I know about NFTs and bits and all that is completely at the user consumer level, not at the research level. So I try as much as possible to avoid it. And like I mentioned earlier, I've learned a lot from the discussions from the first two presenters. So I will just quickly do a quick overview of what I learned from the whole presentation, and probably just pick up the button from where Senator ended. The Senator did mention something, and I'd like to just hang a bit around that area. The issue of talked about Dreamwriter. Yeah, I think he made a comment about Dreamwriter and the confusion that's always going to be there when we have intelligent systems. The struggle to patent things done by intelligent systems. And then the issue with responsibility. Who do we hold responsible? There's this perception generally, I've mentioned this earlier, that the main idea behind automation of systems is more of a capitalist perception, big companies trying to pass the blame, unquote, to some computer system. And like Senator has said, it's a usual problem. You have things happen, and because they've been automated, the companies behind the systems tell you, hey, it's not us. I've given the instance severally. It's a Tesla car. Well, it's not fully automated for the time being. Yeah, let's assume a fully automated or a fully autonomous car runs into a child on the crossroads, and then there are issues. You start tracing the issues to the programming, who bought the car, who designed the car, who programmed it. It gets complicated. It's more complicated when it gets to courts, and we know we don't want to be in the mix of this. So scientists usually feel that bringing in the issue of ethics and responsibilities, it's strangling science. It does not allow for innovation. So this is the confusion that we have. And there's also, these confusions are going to keep coming up. The more intelligent systems we have, the more, it just expands. Currently, we're struggling with the issue of Davos. Senator mentioned the decision of I think the US Supreme Court some weeks back on Davos. And the lawyer keeps pushing Davos systems through jurisdictions. So far, 17 different jurisdictions around the world have rejected to patent the product by Davos because of the perception that for US, for instance, the US Patent Act defines an individual as a human being. An individual has to be a human being under the Patent Act. This has been repeated by Australia. I think it's just South Africa for now that has granted patents to patent rights to Davos on specific issues. So these issues are always going to be there, and we keep having these problems that come with automation and automated systems, issues of responsibility. Who do we trust this to? And it gets worse because now people are finding ways around the excuses. Okay, I think I saw a message. Yeah, this roadblocks, if I should call them. Earlier this year, a computer program called the GPT-3 wrote a 500-word essay from the beginning to the end, like they call it a 500-word thesis. And one of the scientists, or one of the said authors of the work, had to take permission because the requirements under research ethics is before an article is reviewed, there has to be a permission from the author. So the question was, who is the author? Is it technology, or is it the person that designed the technology, or the person that did the coding and all that? So there could be a breach of, we had so many questions at this point, but smartly enough, the author, unquote, the human author, had received permission from GPT-3, which is also autonomous, had asked for permission to go ahead and put her name as a first author, and that permission was granted. So this just opens another Pandora box of problems completely. And for every action we take, I'm sure this is going to be the same thing with blockchain technologies and all that. For the more we bring in automation into the systems, the complications are going to be more. So I am hoping that with presentations like this, we ask the right questions. I wanted to also talk about the definition of data protection by the fourth group. I think Senator has mentioned it a little bit, but let me just quickly add that data protection doesn't just end with what Group 4 called recovery. It is more like protection itself. How am I sure that what information you have about me, you're the only one that has access to it? How am I sure that my medical information is not with my employer or somebody else? So we've had this in different jurisdictions, and then we also have the issue of data privacy, which I wouldn't want to go into for the lack of time. So once again, thank you very much. Thank you, Juliana, once again for inviting me. Thank you to the presenters, and thank you, Senator Meme and Emmanuel. I saw him earlier. I hope he's still around. Thank you so much.
Okay, thank you very much, Mr. Gabriel. So I think CWC might be having technical issues. So please, let's hear if Mr. Emmanuel is here so that he can just quickly give his comments and we can move on to the question and answers. Do we still have Mr. Emmanuel? Okay, I guess he's not here. So just before we go into the Q&A, please let us on Twitter, write what you learned, and make sure that you thank the mentors, thank them. It's a privilege to have them with us and what you learned, so they know that they are spent. Post what you learned and tag them in it. So please put your videos on, put on? Yes, I can see some people already putting their videos on. Put your videos on, thank you. Take a screenshot and feel free to post on any of the social media platforms. Okay, so while we're doing that, we'll just go straight to the questions for today. We'll just go straight to the questions. Please help me post it, Hussein, in the chat box. Okay, so I'd like to say a big thank you once more to the mentors. Thank you so much for the, thank you for expanding the topic and for bringing life to the discussion today. Okay, so our first question for today will be going to Senator. How legally enforceable are smart contracts? Will smart contracts replace lawyers? I think this has been.
All right. I think that Julian's.
Probably you can just touch it a bit.
All right. Just a quick one, right? So, like I tried to say earlier, smart legal contracts, I think, is what this question is really about. And when it comes to smart legal contracts, are they going to be legally enforceable? My answer is yes, if they meet the legal requirements for enforcement. The same way you have requirements or conditions for a contract, that's the same way it applies with smart legal contracts. So you have your element of offer, there is an acceptance, and there is consideration of that offer. Some Supreme Court cases say that there also has to be intention to be bound by the offer, acceptance, and consideration. If these three things or four things are present, yes, the smart legal contract will be enforceable and can be enforceable. In terms of whether this will replace lawyers, I do not think so. Because when it comes to smart legal contracts, you still have to go back to the elements of law. If it's a smart legal contract on divorce, for instance, you need a lawyer who understands divorce laws and be able to tell you that if you want to program certain provisions into the smart legal contracts, this is what you have to put in there, because it has to be consistent with applicable laws. This applies generally. So lawyers are not about to be replaced at any point in time. I'm not sure if it's just me, but everything seems to be frozen here.
No, it's not. It's not just you. I think I have the same issue over here.
Okay.
I think there's a problem with the internet service of the moderator. Maybe that's why, because every other person seems to still be on.
Yes, I suspect so too. I wonder if there are other members of the JIIPCC.
Well, if that's the case, I think we could just take, because I can see some questions have been posted on the chat box, I could just go ahead with them very quickly.
Please, can somebody tell me where Ms. Juliana stopped, please?
Okay.
I think
so really,
the first question.
You can go on. Perhaps you take the second question.
Okay, the second question. Okay, the second question is for me. Have they asked Mr. Meme any question?
No.
Mr. Meme, have you been asked any question? Okay,
No,
okay. So the next
Sorry, my
question is for
network
Mr.
had
Meme.
issues for a minute. So I'll be asking Meme the
Okay,
next
can
question.
avatars use in the metaverse obtain legal personality?
Yes, definitely. So that's a really interesting question, right? So, obviously the answer right now is that no, avatars do not currently have kind of full legal kind of personality rights, right? And are kind of seen as kind of natural human beings, right? Of course, the question is, can they be, and may they in the future obtain that, right? And I think some of the questions, there's two ways to kind of think about this, right? One is kind of culturally, and the other is a little bit more kind of like almost uh, technologically, right? So from a cultural perspective, right? I do think there will be more of a. I mean, if you look at little kids, I know it happens a lot in the U.S., like the elsewhere as well. A lot of kids will take their parents' phones, right, and they'll play these video games, and they'll pay money to get these different clothes that they wear in these video games, right? And to their parents, it might seem ridiculous. Why are they, spending real money on these fake digital, shirts and stuff just when they're playing with their friends, right? If you think about it from a kid's perspective, why do adults spend thousands of dollars on Gucci and thousands of dollars on Chanel, right? It's because by wearing that, you're expressing who you are to all of yourselves and your peers, right? But if you think about the younger generations who are mainly engaging with their peers in the digital world, it doesn't matter if I'm wearing Gucci behind the computer screen, right? Because like the way that my peers are going to judge me and the way I'm going to express myself is through what I'm wearing digitally, right? And so as more and more of our lives are kind of lived in the digital world, as the merging of the digital and the physical world kind of happens more intensely through kind of the onboarding of the metaverse, I do think culturally we could reach a point where we kind of just don't see that distinction between ourselves and our digital selves because it's just another form of expression. It might be the dominant way of expressing ourselves to our kind of peers, down the line as we, I'm a big space law guys, of course, as we kind of look out there and of course as the metaverse grows. I'd say from a technological perspective, this was a question that was also brought up by one of the groups, but Facebook, I guess Meta is already working on bodysuits, right? Wherein, and so that idea of tracking eye movements, once you have a fully functional metaverse on treadmills, every movement you make will be a data point that is being stored by someone, right? And then just from that pure perspective of that tracking, from a technological perspective, it might make sense to then kind of recognize avatars as a personality because they just from the sake of how much data about you that's personal are being created and going through them, right? And so those are two angles I'd look at it. Answer is no right now, but of course, it could be interesting in the future.
Thank you, Meme, for that response. So the next question is, what is the future of fintech in the metaverse ecosystem? What is the future of fintech in the metaverse ecosystem? Sorry, you're muted.
Sorry about that. Yeah, that's interesting. I mean, when you say the metaverse ecosystem, right? What does that really mean? In that, like, there's all different kinds of things that folks call metaverses, and it really is just kind of a merging of a digital and kind of physical world. I think a lot of the prominent ways, obviously Meta and Fortnite and stuff like that isn't on the blockchain, but people do think a lot of kind of blockchain, based metaverses because those are decentralized, and I think it's taken a lot of mind space, Decentraland, crypto voxels, etc. And so I think from that perspective, it'd be decentralized finance, right? DeFi, which is kind of, a burgeoning mode of kind of finance that's born on the blockchain that would probably end up being the defining, kind of fintech in that metaverse ecosystem. I'd say like in worlds like Decentraland, JP Morgan Chase has already bought land in Decentraland. And you can go to their bank in Decentraland and perform kind of online kind of transactions that you'd be able to do from an app, for example, right? And so I do think from from that perspective. But you know, if we're looking out into the far, far future of if I'm living and working in the metaverse, you know, how does all of that kind of work from an economic, you know, perspective? You know, I would say that for a lot of these decentralized metaverses today, like Crypto Voxels, Somnium Space, Decentraland, you log into the world and all of your data is stored through your digital wallet, right? It's not that you have a login through Facebook, right? It's actually your digital wallet, and the assets, the land itself is an asset in that wallet, right? And so I guess from that perspective, I would just look at the future of DeFi to maybe be looking at, because it seems like for a lot of these metaverses, the decentralized finance will be kind of what drives that side.
Okay, thank you, Meme, for the response. So our next question will be going to Senator, and second, what are the loopholes in the NDPR that an amendment to the regulation or another law might help to solve? What are the loopholes in the NDPR that an amendment to the regulation or another law might help to solve? This is to Senator.
All right. So one of the areas that have been pointed out by players in the space is the issue regarding whether in the first place NITDA has the authority over data protection and privacy in Nigeria. As basic as that might sound, it's actually been a big problem because I am aware that there are organizations and players in the industry or across industries who continue to believe that, hey, we are not going to be complying because we do not see the powers of NITDA being really about data privacy and protection, right? So in the new law that we expect Nigeria would be passing, very soon, we expect that issue needs to be addressed so that it is clear that whichever authority is going to be created, such as the one being considered by the what's it called now, the National Data Commission bill, right? If that is sorted out, it will be very good, so that we have all players, complying with whatever that data protection authority is going to be coming up with. Another issue has been really about compliance itself, the compliance mechanisms. There are persons who believe that the current compliance mechanisms may not work because it relies on third parties. How do I mean by third parties? You have those you call the data protection organizations or compliance organizations who are expected to work very closely with NITDA to ensure that there is compliance. Certain groups, or there have been certain concerns that this may not work because there seem to be, it is too lax, right? That it is too lax. We need better enforcement or compliance mechanisms so that people will take data protection and privacy more seriously in the country. Not really in terms of the law now, but in terms of capacity. There is also the issue about whether the current data protection authority, NITDA, has the capacity to be able to ensure enforcement and compliance in the country. That's another thing entirely. I think these are just mainly the issues for me, although some persons have said that there are certain requirements of data protection and privacy that ought to have been reflected in the NDPR. I do not think that they are too fundamental to affect compliance at this level. I personally look forward to the new data protection legislation, which will tend to ensure that Nigeria has a data protection authority that has the rights or the power and authority to regulate data protection and privacy in the country.
Thank you very much, Senator, for that answer. So the next question will still be for you. Given the importance of data protection and privacy, is there an international group or court that regulates data breach worldwide?
All right, so I am not aware of any such international body. Data protection and privacy is a very national issue, and that each country or jurisdiction wants to have powers over. The same way that in the intellectual property space, we talk about the territoriality of IP rights. It's the same way with data protection and privacy. There is nobody, no global body currently that regulates data privacy and protection. The best that we have right now are the data privacy practitioners or professionals trying to come out together under a global body to drive data protection and privacy in their countries. So currently, there is no such international body.
Thank you very much, Senator. So our next question will be going to Mr. Gabriel. Is there enough legislation in Africa for data protection, particularly to regulate AI? Is there enough legislation in Africa for data protection, particularly to regulate AI?
Yeah, thank you. First, the question for me is not usually having enough legislation, but it's like Senator has mentioned, the issue of the capacity of the regulation to be implemented. We have so many countries. As a 2021 December, Zambia was the 31st country to have a data protection regulation so they are out of 50, 54, 55 countries in Africa. If we have over 30, that's a good number. And we also have the African Union Convention on Cybersecurity and Personal Data Protection. So these laws are there, but I think that the major problem is actually with the structures and the capacity to implement these laws. Like I've mentioned in one of our sessions, we even have laws that protect things that are not there. I remember giving an instance with having railway laws that regulate trains that we don't even have, and these are some of the instances. So I think we have enough laws, but the problem is with implementation and people that actually understand how it should be implemented. So this is what I think.
Okay, thank you very much, Gabriel, for that answer. So the next question will also be for you. Can AI and its innovations be practiced in all fairness without tampering with the data and privacy of its subscribers, subjects/person? Can AI and its innovation be practiced in all fairness without tampering with the data and privacy of its subscribers, subjects, and persons?
Okay. When I heard the question, it sounded exactly like asking, can we drill oil without degrading the environment? It's possible, actually, but it's going to really limit how much innovation we can have. Once you start discussing AI ethics before scientists, they tell you that the issue of ethics and regulations are usually very limiting when it comes to AI. So there are certain things that ethically will not be allowed, or legally and ethically, of course, would not be allowed. So yes, it's going to limit it, but it's going to limit it for positive reasons. We cannot allow science to produce whatever it's capable of producing. We have to limit what we do to ourselves, because as it is now, there's already a complaint that we don't know where we're headed with artificial intelligence. A lot of things have been automated. Things are getting out of hand, and our legislatures are already too slow, backward, especially back in Africa, in some parts of Europe, we have regulations for even smart cities that are not yet available. So these things have been put in place. But yes, it's going to be, there's going to be lots of restrictions that come from ethics and laws. And so far, I think, yes, it is. But it's for a positive reason. We can't keep building technologies that we cannot control. That's, my personal opinion. So yes, it's going to restrict how explosive we should be, how innovative we should be with science. But I think it's also necessary to have that.
Okay. Thank you very much, Mr. Gabriel. So I'm going to give the mentees an opportunity to ask their questions live. So if you have a question, please just raise your hand up and I'll be calling you. But just before I call you, I'll just read out one more question to Senator. And then if you have a question, please just raise your hand up, or you can put it in the chat box and I'll call you to ask your question. So this question is to Senator. Will AI be a drawback or rather a valuable tool for IP protection in the domain of NFTs? Will AI be a drawback or rather a valuable tool for IP protection in the domain of NFTs? Okay, I think you touched this a bit earlier.
All right, interesting question. It's always interesting when I get questions around AI and smart contracts because generally people feel that AI smart contract, it's all about automation, which is not very, very correct. So I think that AI has some value we can bring to the NFT space, only in terms of automation, how AI, can help to, gather data, user data, and see how it can intuitively, create certain value in that space. Because right now, what we see in the NFT space is, of course, the encryption of works. What I see right now is that a lot of works are coming into the NFT space, musical works, artistic works, digital works as well, collectibles as well. And there seems to be exactly what we were trying to protect against, which is infringements. A lot of infringement is happening. And I think that all those infringements is happening in that NFT marketplace because of a lot of misunderstanding or misconception about what NFT can do for IPs. What AI, I think, can help bring some sanity into that space is by way of combining the power of NFT blockchain technology to improve traceability, right? Because when we talk about blockchain, we talk about three important elements or features. We talk about traceability, we talk about security, right, as well. And we talk about transparency. Now, having made things transparent using blockchain in NFT space, I think that the traceability aspect can be a lot more improved, maybe by having AI also combined with NFTs to ensure that works can be better tracked, for instance. Also, we need to be able to see if we have an AI author or creator of an NFT, right, also playing in that space, how do we ensure that the work can be traced back to the AI or something? So I think it's just a combination of, we need to have developers really work together some more so that it's not just a single story. For now, I'm not seeing a lot of collaboration happening between smart contracts and AI. I think that they are both working too independently. I think that a lot more can come into that space to improve traceability. So you can trace works to certain authors. You can trace works to, what's it called now? Is what you call the origin, of a work. I think that can also be improved if we, put some or integrate more AI in NFT markets. Certainly, this deserves some thoughts, but these are just things I think we can look at for a start. Hello, Juliana.
Okay, Ms. Juliana is not with us. So is anybody having any of the mentees? If any of the mentees have any question, you can ask now. Okay. In the absence of questions for our mentors, we come to the end of the program for today. We thank all our mentors. Okay. Okay,
Yeah.
you can go ahead.
Okay. Please, I don't know if I got it. If I got what Senator said, but I wanted to know if NIDA. Hello. He said that I'm not sure.
Okay, so I think Juliana is trying to get back, but perhaps Chisom could continue.
Okay, I'm not sure if I got you right. You said there's an issue
Emmanuel,
about
Temitai, or Joe, I think
whether
you are raising your
NIDA,
hand. You can ask your
whether
question.
NIDA. I think there was an issue where you said whether NIDA had was the data protection authority in Nigeria. And I just wanted to ask that in like when you look at the NIDA Act, especially Section 6, can we still say that NIDA is not still the data protection authority in Nigeria? I mean, it gives them like enormous powers and all. And I just wanted to be sure if I heard you right when you said that NIDA is not the data protection authority. Thank you.
All right, thank you very much. So when you talk about a data protection authority, you're looking at an authority who is in charge of data protection and privacy in a jurisdiction, right? My point was this, that Nigeria has various industries where personal data is being used. And I made reference to the telecom sector, the banking sector as well. And I said that in Nigeria, we do not have a sole, perhaps I should have emphasized that, we do not have a sole data protection authority in Nigeria, right? What we have is we have sector-specific data protection authorities, like the Central Bank of Nigeria in the banking and financial system, like the Nigerian Communications Commission in the telecom sector, right? We also have the National Identity Commission as well, protecting data as far as citizens' identity is concerned. These are all data protection authorities in their own rights across their own sectors, right? What NIDA is doing is just to play that role of developing the developing information technology in Nigeria, while also trying to create a lot of awareness and guide compliance or drive compliance with data protection regulations. If you go to the definition section of the NDPR, you'll find exactly what I'm trying to say, where the NDPR itself acknowledged that there are data protection authorities in specific industries that NIDA is going to be working with. So we do not have a sole data protection authority in Nigeria currently. I hope this helps, Chisom.
Yes, it does, sir. Thank you.
Thank you very much, Senator, for that beautiful answer. So we come to the end of today's program.
I have a
Okay,
question,
we
please.
thank our mentors. Does anyone have any questions?
So, I have a question. Can you hear me?
Yes, you can speak.
All right. So, my question is this: for the fact that data protection is all-encompassing. I mean, there is hardly a sector that data protection does not speak or is not involved. So, in smart contracts, I have tried to in my research and all that, I discovered that some principles of data protection will not work in smart contracts. I mean, they still negate each other. There's a clash between the two. So, is there a way that there can be a kind of interplay and then a balance between the two? I mean, smart contract is definitely the next big thing as an influence of AI. But then, if there can be a balance between data protection and smart contract, it may not still yield to any benefit. And if data protection can't be regulated, I mean, is there a way that we can actually balance those two, and then end or achieve the purpose for data protection in that aspect? Thank you.
If you okay,
you can.
All right. Thanks for permitting me to respond to that. Yes, I am one of those who believe strongly that blockchain and cybersecurity is a marriage made in heaven. So unlike how a lot of people see a conflict or a clash, what I see is a fantastic couple that's going to be married for a very long time, very happily, if we really understand what blockchain has come to do. So when you talk about smart contracts, I'll take you to there is an application of smart contracts, right, in the blockchain space, which we call decentralized applications, dApps. Now, when you go to a decentralized application platform, or for instance, I'll give an example of a decentralized crypto exchange, right? Now, we know crypto exchange as Binance, for instance, very popular one. That is centralized. If you go to a decentralized crypto exchange, it means that there is no company, there is no one who is CEO anywhere, is decentralized, no authority. That's the picture you're painting. In that scenario, can we have NITDA, for instance, enforce the NDPR on a decentralized platform like a DEX, decentralized exchange? The answer is this: you will find no one. There is no data protection officer in that company. There is no CEO. So definitely you can't apply it. But is it even applicable? I'll tell you this: in a decentralized app, no one is collecting your data. It is centralized authorities like Binance that collect your data to create an account for you, for instance. In a decentralized exchange, no one is collecting your data. You are 100% in control of your data. If you go to Trust Wallet, for instance, they don't collect your data. You own your own data. So the issue of data protection and privacy doesn't even apply at all. Why? Because there's no central authority collecting your data, storing the data anywhere, or processing that data. It's smart contracts, right? Doing all that. So that's why they say that in that space, you are your own bank. For instance, I was researching or helping one of our clients recover lost cryptocurrencies. And as soon as we traced some of these Bitcoins through the Trust Wallet, which is a decentralized platform, we knew it was the end. You can't get it back. You can't get it back because you are 100% in charge of everything, your data, everything. So I hope that my illustration helps you to understand that with decentralized platforms where smart contracts apply, you do not even have the need for collecting data. No central authority is collecting data. No central authority is processing data. No central authority is sharing data with any third party. You are in charge 100%. So some advocates, privacy advocates, now say that as a matter of fact, what we should have is all of these central authorities that you know today should apply blockchain so that there will be no need for them to collect data. Data should remain in the hands of the data subjects. Interesting stuff, right? So that's the idea. That's why I say that when it comes to cybersecurity or privacy, blockchain and cybersecurity is a marriage made in heaven.
Hi, everyone. And first of all, I would like to apologize for my internet. It has been quite bad, but I really want to appreciate the other mentors. I can see they're doing a very great job, super good. In fact, I'm so happy to bounce back and catch up with the little that I have had today. And sorry, I have not contributed much, but any of you can still chat me up so that we can have some private discussion so that I won't take much of our time. Let me just fall back. I really appreciate Senator for making some kind of clarification. And I really appreciate him making it very, very plain, because when you talk about data protection, there are certain parties that play roles like a controller and a processor, and you trying to bring it into the blockchain world, it does not apply there. Now, there's yes, we know that the blockchain world is fast developing, and it is still moving in a pace that there are certain legal principles that are yet to be applicable. In fact, even the well-known IP rights, that the conventional IP rights that we practice, most of it cannot be applicable on the blockchain platform. So there's so much still left to be on the table to pursue. So I think trying to equate data protection with the blockchain technology is quite still early. Probably in the future we can do that. Thank you.
Thank you very much, Mr. Emmanuel, for joining us late. So the final question is, Busisiwe, I think you raised your hand, so you can ask your question.
Yes, but I see that Meme has already left, so the question was directed to him. But maybe one of the mentors could help understand what could possibly be the next. What would the definition of territory be, especially because IP is very territorial in the metaverse or virtual reality in general?
Okay, Senator, please, you can help us.
All right. So the thing with technology is that it makes the world a borderless world. There are no borders with the internet, for instance. But as we also already see, when you trace, Internet 1.0, when all that internet was static, to the interactive internet we have today, with Internet 1.2, Internet 2.0, what you find is that however way the internet tries to create a borderless world, jurisdictions will always emphasize or drive that conversation towards we have territorial control. These are the boundaries. So if the Internet 2.0 hasn't changed the fact that there are national or territorial boundaries, I do not see how Internet 3.0 is going to change that. Because it's all about, it's still the internet. The Tapscott brothers, who wrote a book on blockchain technology, did acknowledge that, hey, Internet 3.0, which is where we are today, which is what blockchain is It's going to bring the metaverse, Web3 and all that. But at the end of the day, it is still the parties, you and I, whether as a natural person or as a corporate person, who are going to be interacting with this new internet of value, exchanging value. So yes, for instance, Bitcoin doesn't have any borders. I can send Bitcoin from here to Kenya, to California from where I am. And because it's borderless, you begin to wonder whether there will be any kind of territoriality. There won't be. But as far as laws are concerned, if I transfer something of value from here to another country, the laws of those relevant countries will apply. So I don't think that it's going to be different with the metaverse. It's not going to be Freetown. Even in Freetown, I'm sure nothing is really free. So people still need to be very, very careful about what they do on the metaverse. In 2017, a lot of people did what is called the initial coin offering, ICOs, raised millions of dollars through members of the public for their various projects. It's reported that over 90% of all those projects failed. But guess what's happening now? The Securities and Exchange Commission in these countries, US, mentioned them, are now going after the guys that raised money long ago in 2017. So whatever things we're doing on the metaverse today, and think that it's borderless, there is no law governing it, at some point the law will catch up. And by the time it catches up, it will apply exactly how we understand the world today. So let's always have this in mind. I'll wrap up now. Whenever we think about internet, technology, no matter how advanced, at the end of the day, regulators, law enforcement agencies, governments will focus on one thing: who are the parties involved? Full stop. And that answers all the questions. So the law will always follow the parties and be a bit neutral to the technology. That's what's going to be happening. So technology won't change anything.
Okay, let me make a little contribution. Sorry, let me just make a little contribution. Like so far so good, the operations of regulations have been on national implementations, but gradually we're moving into an era where most of these technologies are built with regulations that come by default and design. And by so doing, I think that will actually most likely replicate itself in the metaverse. Those laws will come with the metaverse, and it will be implemented in the metaverse. So laws are actually dynamic, they are changing and they are moving with the evolving technology. So we should expect a lot of regulations implementing by default and by design. Thank you very much.
Okay, very big thank you to all our mentors. Thank you so much for being with us. Thank you for sharing, and thank you for helping us to understand this topic. And I think that everyone has enjoyed this session. I want to say a very big thank you to Senator, to Emmanuel, to Meme, and to Gabriel. Thank you so much for your time. Thank you for sharing. Thank you for being so open with us and for bringing the practicality to the presentations that were made. And with that, I want to say thank you so much also to the mentees. Thank you for researching. Thank you for working together to ensure that you deliver a beautiful and well-researched presentation. So with that, we've come to the end of the session for today, data, IP, and technology. Thank you all. Thank you, Hussein, for helping. Thank you, Sewese, for moderating. Thank you, everyone. Have an amazing weekend. Bye. Thank you, Senator. Thank you,
Bye,
BCC.
Ma.
Thank you, Hussein.
Thank you, all our mentors.
Bye,
Thank you,
bye.
Ma.
Thank you, mentors.
Bye.
Bye-bye, ma. Thank you so
Chelsea.
much, ma.
Just thank you, everyone. Have an amazing weekend. Bye.
Bye, ma'am. Bye, Mr. Senator.